Good morning, my friends. Today I am going to discuss with you about the importance of framing of charge and 313 question. And also, if more than 5 persons were tried and some of them were acquitted, considering that their presence during the course of occurrence was not proved, that the question of 143 did not come to play. So far other accused is concerned, that was the ratio, regular ratio. Here again, AIR 2023 Supreme Court page number 63, AIR Supreme Court 63 page number 63, Kali Charan versus Uttar Pradesh. Therein they have reiterated the ratio that condition must be there should be unlawful assembly 5 persons. One of the accused was acquitted. So, only 4 accused remain. Charge 148, 149 cannot be sustained. Then other question was 213 illustration E. The 213 illustration 3 has been discussed here, cr.p.c by the judge. See. It is most important. It will work for you whenever you argue for charge. When the nature of case is such that the particulars mentioned in the sections 211 and 200 do not give accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the manner in which the alleged offence was committed as will be sufficient for that purpose. So it should be more illustration was given under 213. When a charge contains an allegation that A is accused of murder of B at the given time and place, charge need not state the manner in which A murdered B by going by the charge framed this. It is alleged that therein it was accused number 2 who murdered deceased Harpal Singh by firing bullets from his pistol. Though the case of the prosecution, as can seen from the evidence, is that the accused 1, 2, 3 committed murder of Harpal Singh by using sharp weapons in their hand, there is no charge framed against accused 1, 2, 3 for alleging that they murdered Harpal Singh, as there is no charge framed against 1, 2, 4 committing the murder of Harpal Singh. Illustration E will apply. Therefore, it was necessary to frame charge in terms of Section 213 by stating manner of committing the offence of murder by accused 1, 2, 3. So this is most important. Then they say Section 215 effect of errors. They say no error in stating either the offence or particulars required to be stated in the charge, and no omission to state the offence or those particulars shall be regarded at any stage of the case material unless the accused was in fact misled by such error or omission and it has occasioned failure of justice. This is most important. Then the question of the Supreme Court also said there was no question put to the accused about post-mortem body, material circumstances brought on record against the accused in evidence that deceased died due to injuries caused by the attack made by the accused person was not put to any of the accused. Therefore, in the absence of this framing of 313 questions plays vital role. Therefore, you have to play your trial of defense very cautiously, that instead of pointing out your intelligence and knowledge in law that the court is not framing issues properly, but you should remain calm and allow them to commit errors so that at the time of appeal you can agitate this. This is the art of the trial. See, actually in civil cases what happens, the disputed facts, the plaintiff averment as well as written statement, the court will frame issues. While framing issues, they will see that what was the remedy for, what was the fact to be proved. For that, the issue facts and issues are being framed. But the plaintiff counsel as well as defense counsels are at liberty may give draft issues. But here, framing of charge is exclusive duty of the magistrate or judge who try the case. We can only argue for discharging the accused that there was no material to frame the case. Sometimes it happens when if you say that there is no material to frame charge, then the judge may use his intelligence and experience in framing the charge. But you allow him to frame charge. Then you go for discharge, then the court may think there is no material to frame charge. Because to fulfill section 211, 212, 213 plays vital role to be strictly followed by the court while framing the charge. This is the aspect. You should consider the judgment. The senior advocates and aspiring advocates for judges may go deep. And so far, All India Bar Association examiner must see what is the difference of framing of article charge 211 and 22, 212 and also 239, which plays pivotal role while challenging. So that is more. Then 313 question. 313 question says the court can after recording the evidence, they can select certain aberrament of the witnesses which incriminate the accused in commission of offence and warrants your explanation. That plays vital role. Okay, this is all you must know, understand, I think. But so far, what had happened yesterday, 2:15, I went there in court premises at 2 p.m. itself, but I could not place seat. All youngsters, booth agents, some of them, not all, captured the seats, facilitating their leaders, paying leaders to occupy it conveniently. And when the judges arrived to the dais, I was cornered to last extent, so there is no possibility for me to listen the argument and watch the proceedings. Therefore, I simply walked out. And I must thank one honorable judge, so I am not supposed to mention his name, at par with male judges. She sat up to near about 8 p.m., even tolerating all our necessities. Such a great judge I had seen ever. It's a God-gifted judge. I hope long live and a high position to the judiciary. It's all right, I can say that. But so far here is concerned, some of the advocates wanted me to argue before the court. How can I argue? So these all are things. Let them face whatever what they sow. They have to harvest. I can't say more than that. Whatever it may be, they themselves by gathering heavy and allowing some of the advocates who normally argues even court's orders and favorable order, even after getting favorable, they used to argue for hours together. It's all our fate. We can't change our fate. It's all right. And such a God gift judge, you are. Let me see how you are using this. But I do not understand. I predict that there is no possibility of conducting election for about a year near future. I hope because let there be some and I congratulate all 63 designated senior advocates. I know all 63 persons. Their performance are very good. They are training, learning, exhibiting themselves, maintaining uh, good things. But I was recommended for senior counsel some 20 years back itself. That time only if two senior advocates recommended, but I do not want to be a senior advocate because don't want to dissociate with the clients and young juniors uh, because I want to lift them up by allowing them to climb over me. Best wishes.